Good evening, friends. My name is Harshit Dwivedi and I again welcome you all to my audio tutorial. It has been a long time since I have uploaded one of my audio tutorials. Before this audio tutorial, I have uploaded of around 25 audio tutorials in which I have told you about various things that were happening in the Indian polity in the pre-independence era. That is before 1947. Now in today's audio tutorial, I will tell you about the part 1 of the Indian Constitution. That is, I will cover from Article 1 to Article 4 of the Indian Constitution. Now, starting Article 1 of the Indian Constitution. Article 1 of the Indian Constitution describes India, that is Bharat, as a union of states and not a federation of states. Now, first of all, before elaborating on this statement, I will like to tell you that if we talk in a layman language, or if we go to the core issue, we will say that according to Article 1, the territory of India can be classified into 3 territories. The first one is the territory of the states, the second one is the union territories, and the third one are the territories that may be acquired by the government of India at any time. Till now, by these 2 things that I have told you, the first that I told you that India, that is Bharat, will be a union of states and not a federation of states, and the second thing that I told you that according to Article 1, the territory of India can be classified into 3 categories. First was the territory of the state, second was the union territories, and third was the territories that may be acquired by government of India at any point of time, whether it is through secession, whether it is through purchase or a treaty or anything like that. Specific examples of the third type category I will tell you after some time in this lecture only. So now I will tell you that in Article 1 of the Indian Constitution, the states and territories will be specified as in the first schedule. Now, presently, there are 28 states that are the members of the Union. Now, before telling you the name of these 28 states, I will like to tell you a simple difference between the territory of the Union and between the territory of India. Or we can say that at some places we have heard an expression that is Union of India, and at some places we have heard expression that is territory of India. Now when we say Union of India and when we say territory of India, these 2 things are not the same. That is, Union of India is not exactly the same as territory of India. Now the main difference between this Union of India and this territory of India is that the Union of India includes only the states which enjoy the status of being members of the federal system and share a distribution of powers with the Union. This is the meaning of Union of India. That means that Union of India, this statement will comprise the 28 states which work in a federal form of structure with the central government. Whereas, when we use the term territory of India, the territory of India includes the entire territory over which the sovereignty and control of India for the time being extends. That means in the territory of India, all the states are covered and all other territories on which the Indian government has control at that particular time will also be included. So by this we come to know that Union of India is basically a sub part of the territory of India. When we say about Union of India, please remember this also. While writing an answer is GS mains paper of civil services examination, maybe it is totally possible that you can be confronted with these two statements, that is the Union of India and the Territory of India. So Union of India is only the 28 states of India. Maybe after some time, Telangana is going to be formed in some time, and there is demand for many more states on the basis of language and culture and many more things, thanks to the diversified culture of our country. So as soon as the states will increase, the political map of the country will be changed, but the Union of India term will comprise the states, while the Territory of India will comprise the states and all those territories on which the control of Indian government extends. Now, you must be remembering that at the start of this audio lecture, I told you that there are three types of territories of India. Those three types of territories, the first one was the territory of the state, the second one was the union territories, and third one was the territories that may be acquired by the government of India at any time. This I told you at the very start of this audio tutorial. Now, I have already told you that these territories of the state form the Union of India. The second two territories, that is the Union Territory and all those territories that can be acquired by Government of India through an act, purchase, treaty, secession, they will form the second class of territories. That is those territories which if we include with the Union of India, the whole territory of India will be formed. So the union territories of India since 1987 are 7 in number. Since 1987 there are 7 in number. Their respective names are Delhi, the Andaman and Nicobar Island, Lakshadweep, Dadra and Nagar Haveli, Pondicherry, Daman and Diu, and Chandigarh. Now, out of these 7 union territories, 2 union territories, that is the Union Territory of Pondicherry and the Union Territory of Delhi, which is also being named as the National Capital Territory of Delhi by Article 239 AA. Now, the Union Territory of Pondicherry, the Parliament has by enacting a law that is also famously known as Pondicherry Administration Act 1962 under Article 239A made a provision for a legislature in Pondicherry, and also the same thing was done in 1992 for Delhi, thereby naming it as the National Capital Territory of Delhi. So through this, 2 union territories, that is the Union Territory of Pondicherry, which is also called as the Union Territory of Puducherry, and the National Capital Region of Delhi, these 2 territories have their own legislature, and all the rest 5 union territories are centrally administered areas that are to be governed by the President acting through an administrator appointed by him and issuing regulations for their good government. This is in detail covered under Article 239 and Article 240. Now, these small things are there which in between I am mentioning. I know that this is not necessary to tell here with the Article 1 of the Indian Constitution. But right now, I am telling you regarding this is that while studying Article 1, you get a mere outline of how many things are associated directly with this Article 1. Now, when I will be telling you Article 239 and Article 240 in my subsequent lectures, I will tell you in detail what happened at these places. But right now, I am not telling you about this because currently our focus is to look at the provisions that are being covered under Article 1 and Article 4. Now, Covering these things in detail also depends upon what exam we are preparing for. If the guys who are listening this audio, if they are preparing for civil services examination, then I will advise them to refer two books. I will advise them to refer two books, that is M. Lakshmikant and the second one is Durga Das Basu. Both the books, M. Lakshmikant and Durga Das Basu, they both are effective. But while reading these two books, that is the M. Lakshmikant and Durga Das Basu, before reading Durga Das Basu, it is advisable that you read M. Lakshmikant first. The reason for this is that M. Lakshmikant's language is a bit easy. Now in the market, there are many persons who will say to you that M. Lakshmikant is copied and it is cut copy paste. It is a cut copy paste of Durga Das Basu. But the point is that in Durga Das Basu, everything has been written in very much detail and the language is a slightly tough. It is not very tough, but it is slightly tough. So I will say that if in the first instance you have made a reading of M. Lakshmikant, then Durga Das Basu will become easy for you. And if you are especially preparing for civil services examination, Durga Das Basu reading is a must. Not only reading, you should have the whole book of Durga Das Basu photocopied inside your mind if you are preparing for civil services examination. If you are not preparing for civil service examination, what I am telling you in these audio lectures is sufficient. There is no need to study anything else. That means if you are preparing for Bank PO, if you are preparing for SSC CGL or any other exam except the civil services examination, the content that I am making you available in my audio tutorials is more than enough. You don't need to study anything else. But if you are studying, if you are preparing for civil services examination, then in addition to these audio lectures, it is important that you refer two books. The first one is M. Lakshmikant, the second one is Durga Das Basu. Now, the advantages of what I am saying to you to do, that if you are going to refer these three things, first you listen my audio tutorials. After listening to my audio tutorials, you refer these two books. Now after listening my audio tutorial, when you will go to these books will become a bit very much easier for you. That means that many of the things I am telling here, 70 to 80% of the things I am telling here, 20 to 30% I am dropping, because then my audio lecture will become too much cumbersome, which I am not planning to make, as this lecture I am not preparing only from the point of preparation of civil services. I am preparing this lecture from the point of preparation of all exams, be it civil services, be it Bank PO, be it SSC. The only thing I am saying here is that these lectures are sufficient for candidates who are not preparing for civil services. And the candidates who are preparing for civil services need to refer only two extra books, M. Lakshmikant and Durga Das Basu, in addition to these lectures, in order to prepare for civil services mains examination. Even civil services pre-examination will be covered in these audio tutorials. Okay. Now coming back, I have already told you that the Union Territory of Pondicherry or Union Territory of Puducherry and the National Capital Territory of Delhi, these two have their own legislatures. All the rest 5 union territories, that are Dadra and Nagar Haveli, Daman and Diu, Chandigarh, the Andaman and Nicobar Islands and Lakshadweep, these all 5 are centrally administered union territories. Now, in Article 246(4) of the Indian Constitution, it is being mentioned that any territory which may at any time be acquired by India, either by purchase, treaty, secession or conquest, will obviously form part of the territory of India. This territory will be administered by the Government of India, subject to legislation by the Parliament. Now, a live example of this acquired territory is that when the French settlement of Pondicherry, which included in it the areas of Karaikal, Mahe and Yanam, it was being ceded to India by the French government in 1954. and it was being administered as an acquired territory till 1962. Because till 1962, the Treaty of Secession was not being ratified by the French Parliament. As soon as the ratification of French Parliament was obtained, these French settlements, that is these areas of Karaikal, Mahe and Yenam, which we combinedly say as French settlement of Pondicherry, these territory began to constitute a union territory in December 1962. So they were being ceded to India by the French government in 1954, but they were transformed into a union territory in December 1962, because till December 1962 the French Parliament had not ratified the respective Treaty of Secession. That means that from the period from 1954 to the period of 1962, this French settlement of Pondicherry was being governed as an acquired territory. Now I think that you would be clear on this fact, that what is the difference between the territories of states, what is that, and that union territories and acquired territories. The 28 states that are being mentioned are Andhra Pradesh, Assam, Bihar, Gujarat, Haryana, Karnataka, Kerala, Madhya Pradesh, Tamil Nadu, Maharashtra, Nagaland, Odisha, Punjab, Rajasthan, Uttar Pradesh, West Bengal, Jammu and Kashmir, Himachal Pradesh, Manipur, Tripura, Meghalaya, Sikkim, Mizoram, Arunachal Pradesh, Goa, Chhattisgarh, Uttaranchal and Jharkhand. Of these 28 states, there is one state we all know, Jammu and Kashmir. This state still enjoys a very special position under the Constitution, and the provisions of the Constitution with which the rest 27 states are governed are not applied to the state of Jammu and Kashmir. The special status of the state of Jammu and Kashmir is being mentioned separately in Article 370 of the Indian Constitution, which I will obviously cover in my subsequent lecture. So I am skipping that here. One thing that I will like to tell you in particular here is that the process of joining of Sikkim as an Indian state. Sikkim state was ruled by Chogyal dynasty in the pre-independence era under the British paramountcy. But after that, slowly and gradually it was being mixed in the Indian Union. But it is a very long process. The mixture of Sikkim, first it became the protectorate, and then afterward it was being added as a full-fledged state of the Union. It is a very huge process, and at this point I will not tell you about how Sikkim was included in the Indian Union, as then the lecture will become a bit cumbersome. It is only important from the point of view of the students who are preparing for civil service examination, and for them I have already told that they can refer to the books as Durgadas Pasu. If you want me to upload the lecture regarding the processes that took place in the joining of Sikkim as a full-fledged state of the Indian Union, then you can leave your views in the comment section on this page. And after looking at the comment, if I see that enough response is there and many people are trying to get that lecture, then I will upload it. That is not a problem for me. But I don't think that there are guys out there who are interested in listening this much deep in my audio tutorials. The day I will find that the guys are interested, I will upload it. So the Sikkim part I am skipping here. So till now in Article 1 I have told all the names of the 28 states, all the names of the 7 states, and I have told you about those 7 7 union territories, and out of those 7 union territories, 2 union territories, Puducherry and Delhi, have their own legislature, and some other things, some other important things that are covered under Article 1 of the Indian Constitution. Now, after covering Article 1 of the Indian Constitution, I will come to Article 2 of the Indian Constitution. Now, Article 2 of the Indian Constitution confers two powers on the Indian Parliament. The first power is the power to admit into the Union of India new states. And the second power is the power to establish new states. I repeat, the first power is the power to admit into Union of India new states, and the second power is the power to establish new states. Now, in very brief, I will tell you that the first power refers to the admission of states which are already in existence, while the second refers to the establishment of states which were not in existence before. Now, this basically Article 2 confers power on the Parliament, the power to change the political map of India. So these are the very small 2 points that are being covered under Article 2. Now I will directly jump to Article 3. Article 3 deals with the internal readjustment of the territories of the constituent states of the Union of India. Article 3 of the Indian Constitution gives permission to the Indian Parliament to: first point, increase the area of any state; second point, diminish the area of any state; third point, alter the boundaries of any state; fourth point, alter the name of any state; and fifth point, form a new state by separation of territory from any state, or by uniting two or more states or parts of states, or by uniting any territory to a part of any state. Now, by listening to all these 5 clauses, you would be very much sure that Indian Parliament has the authority to break any particular state into any number of states, or he can take a particular part from one state and another particular part from second state and can mix them to form them a new state, or he can take a part of a union territory and mix it with a part of some other state and anything. The point is that Indian Parliament is 100% authorized by the Indian Constitution to change the political map of India in order to increase the administrative efficiency of the governance. But the application of all the above powers of the Parliament, as mentioned in the Constitution, is subject to the below premise. The premise is, I will read it and then I will explain it. That it is provided that no bill for the purpose shall be introduced in either house of the Parliament except on the recommendation of the President, and unless where the proposal contained in the bill affects the areas, boundaries or name of any of the states, the bill has been referred by the President to the legislature of the state for expressing its views thereon within such period as may be specified in the reference, or within such further period as the President may allow, and the period so specified or allowed has expired. Now, this thing that I have read, it is a bit difficult, but what I read was a legal language, and legal language is always complex, and this is one of the, you can say, errors, I will not say error, it is one of the shortcomings of our Indian Constitution, that the language of our Indian Constitution is a bit legal in nature. And when the language is legal, then it becomes difficult for students who are not of the law background to understand it easily. So that is why while studying for Civil Services General Studies, many students are there who do not refer PM Bakshi, because the language of PM Bakshi is legal in nature, and legal language is difficult to understand for non-legal background students. So that is why I recommended you Lakshmi Kant and Durgadas Basu. So I will tell you the meaning of what the premise means. That is that a bill contemplating any of the changes that the parliament has the authority to increase the area or decrease the area or alter the boundaries, change the name, or you can say that form a new state by mixing a part of any union territory or a state or two states and anything like this. A bill contemplating anything like this can be introduced in the parliament only on the prior recommendation of the president. This is the first condition. The second condition is that before recommending the bill, the president has to refer the same to the state legislature concerned for expressing its views within a specified period. That means that before the parliament can initiate this process of changing the area name, diminishing or forming new states, this bill can be introduced in the parliament only on the prior recommendation of the president, and before recommending this, the president shall refer these bills to the legislature of the state concerned and will ask about its views regarding the same. However, the views or recommendations that will be given by the state legislature to the president are not binding on the president. That is, that suppose that a bill is introduced in the parliament who says that the area of a state will be diminished and a state will be seceded out of that state. Now, suppose there is a state named X state, and from that X state, area has to be removed and to be formed a new state. Now, a bill to do this, first the bill will be sent to the state legislature of the X state and its views and recommendations will be asked. After the views and recommendations of the states are received by the president can listen to the recommendations of the state legislature, or he can also totally ignore them. That is, that the expressions and recommendations of the state legislature regarding the provisions which are mentioned in Article 3 of the Indian Constitution are not binding upon the president. That is, the president here is not bound to act on the advice of the state legislature. Now, I will like to explain this thing to you by comparing this Indian scenario with the American scenario. That means that two phrases are used for India and America. For India, it is being said that it is an indestructible union of destructible states. And for USA, it is being said that it is an indestructible union of indestructible states. Now, we have to understand these two things in detail in order to understand Article 3 totally. The point is that when United States was formed, then it was formed by the treaty of several different states. That is, that when American Federation was formed, it was not formed by annexation, or it was not formed by, you can say, coercing someone to join us. It was formed by a treaty. And when a treaty is formed, then any changes in that treaty obviously has to be ratified by all the members or party to the treaty. It is as simple as that. That is why United States is being called as an indestructible union of indestructible states. That means that all the states that are being in existent in the United States, their area or their you can say territory cannot be changed without the prior approval of that particular state. And those states are totally autonomous in their functioning. While in India, the formation of India is not, you can say that it is not a agreement of all the states of India. During the partition time in 1947, it was a very, you can say, very difficult period. And the circumstances at that time were very much tricky, very much difficult, and very much violent. Bloodbath was going on. Communalism was at its height, at its peak. So at that time, the Iron Man of India, Lal Bahadur Shastri, did this great task of uniting India. And he used all the tricks and trade of the book in order to do that. So we can say that all the states of India or all the territory of India was not constituted, was not made by a secession or a treaty. Some parts were taken by secession, like Sikkim. It was a gradual transformation of a Sikkim from a protectorate to a full-fledged state of the Indian Union. But some other areas were there that were being annexed. Some other areas were there that were being coerced to join India. So the point here is that I am trying to say that India is an indestructible country consisting of destructible states. That is, that the Indian Parliament is authorized to change the political map of India. Now, with this, I complete the Article 3 of the Constitution. Now, I will tell you about Article 1, Article 2 and Article 3 of the Constitution. Now, I will come to Article 4 of the Constitution of India. Now, Article 4 of the Indian Constitution declares that laws made for admission or establishment of new states, that is Article 2, and formation of new states and alteration of areas, boundaries or names of existing states, that is Article 3, are not to be considered as amendments of the Constitution under Article 368. This means that such laws can be passed by a simple majority and by ordinarily legislative process. It means that Article 4 provides that any such law may make supplemental, incidental and consequential provisions for making itself effective, and may amend the first and fourth schedule of the Constitution without going through the special formality of a law for the amendment of the Constitution as prescribed by Article 368. This point says that there is a process which is being mentioned in Article 368. Article 368 totally covers about the provisions that are being required to be met in order to amend the Constitution of India. Now this Article 4 says that the provisions that are being covered under Article 2 and the provisions that are being covered under Article 3, for implementing them, we have to not abide by the provisions of the Article 368. That is, anything done by the Indian Parliament in the name of Article 2 and in the name of Article 3 does not require a Constitutional Amendment Act. That is, it does not comes under the ambit of Article 368. That indirectly means that these laws can be passed by a simple majority and by the ordinary legislative process of the Parliament. So basically, the job of Article 4 is to protect Article 2 and Article 3 from the ambit of Article 368. So friends, in this audio tutorial, I have told you in detail from Article 1 to Article 4. At the last, I will like to tell you one point that may be confusing for you in this total audio tutorial. That is that the difference between Article 2 and Article 3. There is a very slight difference between Article 2 and Article 3. Is that Article 3, I have told you in detail, deals with the increasing the area of any state or decreasing the area of any state or altering the name or boundary of any state, or by merging two or more states to form new states, or by merging two or more union territories to form a new state or union territory or anything like that. The point is that Article 3 deals with changing the political map of India, while Article 2 deals with the addition of new states into the Indian Union. That means that if we are going to join a foreign territory in the territory of India, or if we are going to join a foreign state into the Union of India, that is into the states of India, then those provisions are covered by Article 2 of the Indian Constitution. One more point, there was a small controversy regarding Article 4 in 1960. This controversy is famous as Beru-Bari Union case. Now, it came forward that under Article 3 of the Indian Constitution, Indian Parliament has been given the power to change the boundary, to increase or decrease the area, to change the name, and to merge two states or two union territories to form a particular state or a union territory. But is this article covering the secession of any Indian territory to a foreign territory? That means that on the basis of Article 3, can we say that Indian Parliament has the power to give some part of our territory India to any foreign country? This issue came forward during the Beru-Bari Union case before the Supreme Court in 1960. At that time, the central government decided to cede a small part of our territory known as Beru-Bari Union, that is West Bengal, to Pakistan. But that led to political agitation, and the matter then came to in front of the Supreme Court, and the Supreme Court held that the power of Parliament to diminish the area of a state that comes under Article 3 does not cover secession of Indian territory to a foreign territory. Hence, Indian territory can be ceded to a foreign state only by amending the Constitution under Article 368. This means that Article 4 protected Article 3 by not taking it under the ambit of Article 368. That is, Article 3 was kept out of the ambit of Article 368. But with the Supreme Court ruling that said that secession or giving of our territory, of any part of our Indian territory to a foreign territory, will involve an amendment in the Constitution, and therefore, according to the provisions of Article 4 and Article 3, Article 3 does not confer on the Parliament to give any part of the territory of India to a foreign territory. So, in order to remove this flaw, the 9th Constitutional Amendment Act 1960 was enacted to transfer the said territory to Pakistan. So this case is very much famous as the Beru-Bari Union case. It was a part of the West Bengal at that time. So friends, Article 1, Article 2, Article 3 and Article 4, I have told you in very much detail what these articles deals with. There are a lot more things that I need to tell you here in order to understand more properly these things. And I will not say that Article 1 to Article 4 is totally finished now. It is not finished, because in this thing there are many more things that I need to tell you. the formation of different states, on which date they formed, through which constitutional amendment act, through which provisions they were passed, and when they were passed, and for what reasons they were passed. All these things are still to be covered. And then there was some very important commission set up, that is the Dhar Commission, the JVP Committee, and the Fazl Ali Commission. So in my subsequent lectures, I will upload these also. Already this lecture has been for a long time duration, now around, you can say that this lecture has been now for around 40 minutes. So it has been a huge lecture. So I am stopping this lecture right now. In this lecture, I have told you in detail about Article 1, Article 2, Article 3 and Article 4 of the Constitution. And in my coming lectures, I will tell you in detail about the applications of these articles in real scenarios, how the states are formed, for what reason they were formed, and all the commissions that were set up in order to find the basis on which the new states would be formed. So thank you friends. I will meet you in my next audio tutorial. Have a good day.